She has a mixed professional portfolio of executive level public service, educational leadership in the not-for-profit sector and in academia. In addition, she has in-depth lived experience, research experience, theoretical and practical knowledge in promoting equality, equity, diversity, and inclusion across the lifespan for people with disability. Jill and her colleagues at the University of Newcastle recently published an article on the topic of disability discrimination in the Australian Journal of Education, and it is the second most downloaded article for that journal, which I think indicates the importance of this topic for both parents and educators alike. So welcome, Jill. I'm thrilled to have you here. I'm going to stop sharing my screen so that you can start sharing yours.
Okay, just give me 1 minute or less. All right. Thank you, everyone, for joining us today for this chat about a very important topic. I believe it's a very important topic for all parents of children with any type of disability. And I will say that it can be a rather dry topic, but it is an important topic. And I encourage you to get a notepad and a pen ready so you can start taking notes on slide 15. You can slack off and not pay attention up until slide 15, but once we hit 15, I need you to pay attention. Okay, so let me just acknowledge the traditional owners on the land in which I am and where you are as well. And can I also acknowledge Anne and Bruce and their brilliant work that they do on behalf of parents of deaf children in Australia and really globally. And it is my absolute pleasure to be on the board of ADK. Now, before we begin, I will tell you that I'm in Newcastle. Obviously, you can see the University of Newcastle, but I'm at home and I'm on the hill, and I've got beach, you know, within walking distance, nearly three sides of me, and the wind is howling. And so I hope you can hear me.
I need a boat. I need a boat. I can't help you.
Excuse me, there's somebody, we're getting some feedback.
All right, when that happens, I'll just pause and let you manage that. Before I get started, I do want to say that I'm not a lawyer, you know that already. I am a teacher of the deaf and an academic. And so that means that I cannot give legal advice. I do publish with an academic lawyer. So the publications that we have that look at the DDA and the DSE, there is a co-author who is a lawyer. I wanted to start by giving you just a very brief idea of how I got interested in this topic as a teacher of the deaf and as an academic. So I was very fortunate to be in Victoria. I'm working at a senior position, and in 2016 and 2017 led the Program for Students with Disability review. And that review really opened my eyes. Actually, Anne and Bruce, I think you can actually mute all participants with your controls. So maybe you can look at doing that while I
just ask Bruce, but if I mute myself, we lose the captions.
Okay, I see. Okay, good.
Mute everybody. So could everybody just please check again that you are muted on the screen? Thanks.
Thanks, Anne. So just briefly, that review put me in a context where we had widespread consultation of stakeholders right across the spectrum: parents, students with disabilities, principals, advocates, And it also put me into many, many, many schools. It was a privilege to go into schools and talk to principals, talk to students, talk to teachers. And I also had the privilege of commissioning reports that supported the PSD review. And we had other data that fed into the review. And it just opened my eyes to the fact that this is a wicked problem, okay? This being the education, the non-discrimination in education for students with disabilities. When I did take the position with the University of Newcastle, after leaving my position, my contract finished, and then I moved to the University of Newcastle. I did have a grant to continue looking at inclusive education from a principal's perspective. And so I kept looking into discrimination, investigating what principals thought about discrimination, how it occurred, et cetera, et cetera. And then that led me to invite my colleagues, Renee Punch, who is an academic and also a parent of an adult child who's deaf, Mark Gauntlet, who is a senior academic in the School of Law, and then Ruth Talbot Stokes, who is a senior librarian. I gathered these people, these brilliant people around me, and I said, let's investigate to see if Australia is actually achieving non-discrimination for students with disabilities. So I'd done this PSD review work. I came to Newcastle. I did a couple of years investigating what principals thought, and then I moved to looking at non-discrimination. And so I'd like you to be thinking about what the answer to this question was. So our question was, missing the mark or scoring a goal? Is Australia achieving non-discrimination for students with disability in primary and secondary education? And I'll tell you what the answer is toward the end, but after slide 15, so keep listening. And then, I have to go down here, sorry. So here we go. This is the bit where you can sort of listen, but you don't have to take notes yet. In Australia, I'm sure you know that it is unlawful to discriminate against students on the basis of their disability. I think that's common knowledge. The legislative regime designed to eliminate discrimination against students with all types of disability is the DDA. I'm sure you are familiar with that as well. And then the disability standards for education is the subordinate legislation. So it sits under the DDA. So you really have to know both the parent legislation, which is the DDA, and the subordinate legislation, which is the DSE. However, the right to inclusive education, Australia does not have legislation that mandates inclusive education. Some people misunderstand the DDA and the DSE, and they think that there is legislation that supports inclusive education, but in fact there is not. However, Australia has ratified the CRPD. If you're into disabilities at all, either a parent of a child with a disability, an advocate, a leader in disabilities, it's in your best interest to download the CRPD. It's easily found on Google and read it. So because your rights are embedded in that CRPD because Australia is a signatory to the CRPD. So Article 24 sets out obligations to ensure inclusive education. So we don't have inclusive education legislation, but we are a signatory to the CRPD. And so the obligation to ensure inclusive education that provides accommodations and support for people with disabilities across general education system on the same basis as those without disabilities. We're going to go briefly into what does it mean to be on the same basis. So in the CRPD, it actually says on an equal basis. Now, just briefly, as an aside, we don't really know how many children have a disability in primary and secondary education settings. I say settings because there are a variety of settings, not just school settings. However, we do have the nationally consistent collection of data on school students with disabilities, which incorporates the broad definition. We'll get into definitions briefly of disability a bit later, but the NCCD incorporates the broad definition based on the DDA, not on the state definition of disability. And so you can actually go to the NCCD website. There's a lot of really good, helpful tools on this website if you want to learn about disability discrimination and reasonable adjustments, which we'll get into again in a little while. Go to this website, have a play around. But according to the NCCD, about almost 19% of school-age children require an educational adjustment due to a disability. And again, we'll talk about what does that mean to require an educational adjustment. Just as an aside, so this is an aside because when you're looking at disability discrimination in schools, it's helpful to know how many kids we're thinking about, how many students we're considering. And as an aside as well, you may or may not be aware that government schools enroll more students with disabilities. So that the greater the level of educational adjustment required for the student, the more likely the student is to be educated in a government school. And there's a lot of information about why that is, and a lot of theories and practical sort of, or practitioner guesses as to why it is. So the object, let's get back to the DDA, okay? The object of the DDA, obviously, is to eliminate as far as possible discrimination against persons on the grounds of disability in various areas. So the DDA is broader, but it includes education. The standards, so the disability standards for education support the DDA. It clarifies and elaborates the legal obligations. So you really, if you're going to choose one document, one of the two documents to read, I would suggest the DSC, but really, I mean, they're both very important. And there's lots of tools available to help you understand it, the DSC and the DDA. So we're getting close to 15. The rights of students with disabilities. All students, including students with disabilities, should be treated with dignity and enjoy, that's important, the benefits of education and an educationally supportive environment that values and encourages participation. Unfortunately, there are many education environments where this is not true. The effect of the standards is to give students and prospective students, so currently enrolled students and students who may in the future enroll, so either are looking at schools and talking to various school settings, or will be soon enrolling. So not just current students, but prospective students with disabilities, the right to education opportunities on the same basis as students with disabilities. Okay, including the right to comparable access, service, and facilities, and the right to participate in education unimpeded by discrimination. Actually, I think I should have said 16. Maybe it was 17, but you're listening, so that's good. Now, standards for enrollment. I'm not going over every aspect of the DSC because that would just be too much. So I'm going over some aspects that I think you would find helpful. Standards for enrollment, participation, curriculum, and support services. So education providers must take responsible steps to ensure that students with disabilities are provided with opportunities to realize their individual potential. Individual potential is really important because so frequently school systems, schools, and teachers have this dichotomous view of students and the need for educational adjustments. And so some believe that you shouldn't provide an educational adjustment unless the student is failing or not achieving at the standard, at the average range. But that's not what this says. It says that you must realize the individual potential. So some students with disabilities have enormous potential. And by waiting for them to fail, you are not serving that child. In fact, you're discriminating against that child. So potential is really important. We need to make sure that we maximize the potential of students with disabilities, including our beloved kids who are deaf or hard of hearing. This must be on the same basis as students without disabilities, that the student with disabilities is not subject to discrimination. Okay, here we are. It was slide 17, not slide 15. Sorry about that. Excuse me 1 minute. What I want you to pay attention to is the process, because the process is really important. The process is important for the school, remember, we're not meant to say school, we're meant to say education context, because it doesn't have to be a school. The standards set out a process. So this is what I want you to understand the process, because this can be protective. And so we want to be protective of our students who are deaf or hard of hearing to ensure that they reach their maximum potential. So by you understanding the process whereby education providers must meet their obligations, that will help you ensure your child maximizes their potential, or the school facilitates the maximization of the student's potential. This includes the obligations to make reasonable adjustments, we're going to talk about that, where necessary to ensure students with disability are able to participate in education on the same basis as those students without. Now, here's the process. This is the bit that some people do not understand. There's a couple of bits about the process, particularly that parents don't understand. So the legislation, or the subordinate legislation, the DSC, sets out that the process must include and really begin with consultation with the student. So the word associate is used in the legislation and the subordinate legislation. So the consultation needs to be with the student or the student's associate, which is oftentimes the parent of the student. So you need to start with consultation to get the process right. And so if the school, if it's usually the principal and sometimes the teacher or the deputy principal, doesn't begin with the consultation already, they're outside of the expected process for achieving non-discrimination. And then the consideration of whether an adjustment is necessary. So there has to be consultation about whether or not an adjustment is required. An adjustment could be something like ensuring, for our kids, ensuring there's an educational interpreter, ensuring there's technology that would facilitate the student hearing the instruction, or classmates, or there are lots and lots of different adjustments that can happen for students who are deaf or hard of hearing. So consultation first with the student or the student's associate, parents usually, consideration of whether an adjustment is necessary. If an adjustment is deemed necessary, identification of a reasonable adjustment, okay? So let's think about that word reasonable in a minute. And then of course, the last thing that you do is you make the reasonable adjustment. So if the education provider complies with that process, then they have complied with the standards and they cannot be said to have discriminated. So if they go through those steps and it is an authentic, transparent process, you can't say that they have discriminated. However, education providers are required only to make reasonable adjustments. So that's the problem. Part of the problem, and I think I have a slide on this bit later, is that some of the terms in the legislation and in the subordinate legislation are vague. So what is a reasonable adjustment, right? So education providers are required only to make reasonable adjustments. Education providers are exempt from making an adjustment that would impose an unjustifiable hardship. So there's another term. What is an unjustifiable hardship? Okay, so another vague term that causes a great deal of stress for the student's associate, usually the parents. And I'll sort of describe that in a little bit. So it is actually the responsibility of the provider, the education provider, to demonstrate how the exemption operates. So it's not the responsibility of the student or the student's associate. The education provider has to demonstrate if a reasonable adjustment would cause an unjustifiable hardship. Now, let's talk about just briefly on the same basis. An educational provider treats a student with disability on the same basis as students without a disability if and only if the student has opportunities and choices which are comparable to those offered to students without disabilities, in particular in relation to admission or enrollment. So there are a lot of students who have this, what we call soft discrimination, where when the parent or the caregiver is trying to enroll the child into a school and the principal is trying to convince the parent that there might be a better option for the child at a different school, that's actually what we call soft. Anyway, it is definitely discrimination. And participation in courses or programs and use of facilities and services. Let's move on. Making reasonable adjustment. An adjustment is a measure or an action taken to assist students with disabilities to participate in education on that same basis as other students. Now, the subordinate legislation and other documents will go into much further detail about that same basis that we talked about. An adjustment is deemed reasonable if it achieves this purpose. Well, this is really important. A lot of people forget this or don't understand it. An adjustment is reasonable if it achieves this purpose while considering the student's learning needs and balancing the interest of all the parties. So it's not, in the subordinate legislation, it's not just about the student with disability. It's also about the other students in the classroom and the teacher. So a reasonable adjustment must balance the needs of those parties, okay? And so particularly for kids who have disabilities that include behavioral challenges. Sometimes we get into a bit of, not a bit, a humongous argument because some people think an adjustment should be made with a particular child with a disability, but that adjustment doesn't consider the other people involved, the other kids in the classroom and the teacher. So it is rather complex. The need for an adjustment and the nature of an adjustment should be determined in consultation with the student or their associate. So we talked about that process. So a school cannot just come out, or a principal cannot just come out, or a psychologist or a speech pathologist or a teacher that cannot just write down a reasonable adjustment. It needs to be in concert, in consultation with those people that I mentioned. The education provider should ensure that the process of determining a reasonable adjustment is accessible. Accessible meaning that the process by which the reasonable adjustment has been decided, that everybody in that team has access to what that process is. If the parents have a language other than English, that information is provided in the language of the parents or the language of the associate. And also, so robust accessibility would include spoken information as well as written information, and in the first language of the student and in the first language of the associate. So in deciding a reasonable adjustment, it may be necessary to seek, that should be seek, sorry, independent expertise. So sometimes we have to do that. And in fact, I've been involved in several cases in the Hunter region where I have been an expert on a particular case regarding reasonable adjustments. In deciding if, not for deaf kids, this were for other kids, particularly with complex needs, and that's probably all I should say. In deciding if an adjustment is reasonable, the education provider should consider the nature of the student's disability, information provided by or on behalf of the student. So what information does that school have about the student's disability? They actually have the right to see that information before making a reasonable adjustment. I've been involved in some cases where parents were hesitant to give that information for various reasons. They had just been in loggerheads, I think, with the school, and they didn't want to do anything to help the school. But the school really has the right to see information provided by or on behalf of the student about their disability, how the adjustment affects the student's ability to participate, views of the student's associate, of course, views of the students for older students as well, the effect of the proposed adjustment on anyone else affected. So the teacher, the student, the associate, and if appropriate, other people in the learning context of the child. When considering an adjustment, an education provider is entitled to information. So we talked about that. So you need to be, just like the principal and the deputy principal and the teacher need to be transparent. You need to be transparent about the possible reasonable adjustments that need to be made. Sorry, I'm a bit croaky today. So about the student's disability, information about the student's disability and requirements, if the information is related to providing the adjustment, assessing the provider's capacity to provide the adjustment, and assessment intended to clarify the student's ability. Unjustifiable hardship. So this is, like I said, one of those terms, reasonable adjustment, unjustifiable hardship, on the same basis. There are a number of terms that are very vague in the legislation, that there are several of us academics who are trying to get that legislation changed. Hopefully I remember to encourage you to put your 2 cents in as well to get that legislation changed. So unjustifiable hardship, what does that mean? It is not unlawful for an education provider to fail, to not comply with the requirements if compliance composes an unjustifiable hardship on a provider. But we know unjustifiable hardship lacks clarity in legislation. There's a very famous case. I won't go into detail because I'm not a lawyer. Just to give you a brief example, a student who used a wheelchair for mobility purposes, enrolled in a school. The school had multiple stories. There was no lift in the school, and the student and it was high school student, the student and the associate wanted a lift installed in the school, and the school said there was an unjustifiable hardship in cost. And so that just gives you kind of an idea. In determining unjustifiable hardship, an education provider, again, considers the nature of the student's disability in consultation with the associate and the student, ensures information is provided to the student and associate about the process, because a lot of parents don't understand what that process is, consulting, etc., of determining an unjustifiable, reasonable adjustment and its related unjustifiable hardship. And so that's really important. So how is it that the school has determined that there is indeed an unjustifiable hardship? Ensuring the process maintains dignity, respect, privacy, and confidentiality. And I will tell you, those cases that I've been involved in as an expert consultant, most parties are at such loggerheads that there's a lack of dignity and respect. I don't know about privacy and confidentiality. I don't want to get into that, but for my communication with the parties, there was a lack of respect, particularly. Ensuring compliance. Compliance with standards is the provider's responsibility. So there is a term called positive obligation. So the education provider has a positive obligation to ensure that the student can access education on the same basis as students without a disability. So it's the provider's responsibility. If a student with disability or student's associate, the complainant, if it goes to court, believes that a provider is failing to comply with the standards, a complainant about unlawful discrimination can be made to HERIAC. But I'm not going to go into that. That's a whole different process. I will talk about the complainant process just briefly. Something important, I think this is really important because we know that our kids who are deaf or hard of hearing, and in fact, all kids with disabilities really, but in particular, our kids, under great stress are victims of harassment. And the standards actually require education providers. It's very explicit in the standards. So education providers have strategies in place to prevent harassment and victimization of persons with disabilities, so our kids. So the school, the education provider, has a positive obligation to ensure that there is no harassment or victimization of students who are deaf or hard of hearing, but we know what happens. Education providers must ensure staff and students are aware of the obligation not to harass or victimize students with disabilities. The review of the standard has to take place every 5 years just to make sure it's doing the work. Now, here we go, back to my question. So we're in early 2000, I lose track of time. This COVID situation, I've lost all idea. I have no idea even what month we're in. But anyway, I think it was early 2000. We asked the question, is Australia missing the mark or scoring a goal in achieving non-discrimination for students with disabilities? I wanted to know the answer to this question. I knew from being in Victoria and assisting and being the director responsible for the PSD review that Victoria was missing the mark, but I didn't know if Australia was missing the mark. And so we concluded that in fact, Australia has missed the mark, is missing, can make it present progressive, or you can make it past tense. It's all of that. So the Duncan et al., that piece of that article I just had a picture of, identified weaknesses in Australia's legislative requirement of non-discrimination. I'm only going to go through a few, and then I'll tell you how you can get a hold of that paper. Importantly, parents struggle to understand the rights of their children under the Act and the standards, under the DDA and the DSE. Parents don't understand, the associates don't understand. Well, they're two very complex documents. And the problem is the parents have to be aware and understand the DDA and the DSE to ensure that their children receive the education that they should be receiving in order for them to maximize their potential. Teachers and principals flounder in the application of the Act and the standards. So that was absolutely clear. So remember this paper here came 2 papers after other papers where we were surveying and interviewing principals. And the principals that we interviewed, there was a good portion of the principals. I don't mean to shame principals because it's complex, right? But there was a huge portion of the principals who themselves did not understand. They floundered in the application of the Act and the standards. Systems are required to apply here's the big problem. Huge problem. Systems are required to apply state and territory disability definitions but at the same time, the Act and the standards are Australia-wide. So what that means is that states have a different definition of disabilities than the DDA and the DSE, and it causes real conflict. And no wonder the principals are confused, because they have to balance the state definitions with the Commonwealth definition of disability. So this is just carrying on how we think that the legislation has missed the mark. For parents, the biggest challenge is that it's a complaint-driven system. Like, I spend hours trying to convince policymakers, politicians, that it should not be a complaints-driven system, because it is so difficult for parents to make a change on behalf of their child, to ensure that their child's potential is maximized. It is so difficult because the parent has to undergo a complaints-driven system. Now, I'm not going into detail about what that complaints process is, but what it means is that the enforcement of compliance with the legislation depends on the willingness and ability of often vulnerable individuals. So some parents or some associates have capacity, have capability, and can do it, can make a complaint and follow the complaint through to the highest level to make a change for their students. But some parents are vulnerable. You know, we all have our own vulnerabilities, and some parents do not have the capability or the capacity, it takes both really, to make a complaint. Few cases, here's the real problem, one of the real problems, there are lots of them. Few cases proceed to court, few cases proceed to court, full stop. Conciliation outcomes are confidential, full stop. Those are two separate ideas. So few cases proceed to court, so a decision is made at the court level. A lot of cases where the parent has brought a complaint against the system are settled, for a layperson's terminology. And then the conciliation outcomes are confidential. Nobody can read them. We don't know why it was settled. We don't know who was at blame. We don't know the outcome. They're sealed. So that's that. I did want to say, because a lot of people don't know about OSLI. Some people do know about OSLI. OSLI is a website. And if you are interested to see how other associates, advocates, or usually associate or advocate, brings a case to court, you can go to OSLI, and there is the website, and you can type in, you can search anything. And I just did this quickly last night, and I just searched the word deaf, and 13,360 cases, there's probably quite a few duplicate cases, came up that had some aspect of deafness in there. You can click on, this is just a screen grab, so I can't click on it right. Whoopsie-daisy. Sorry, my mouse is very touchy. And you can click on any of those and learn about those particular cases. Quite a few are about providing Auslan for children who are deaf or hard of hearing. Auslan interpreters, I mean. If I remember correctly, there's a few about the qualifications of people providing instruction for deaf children, those kinds of things. They're not all education related. I'm sure there's a way to search it so it is deaf and education. I just haven't done it. Every once in a while, if I hear about a case in the news, I'll go into OSLI and take a sticky beat because it's kind of interesting. Well, it is a sticky beat. So this publication that I referred to, that Anne so kindly mentioned, is very heavily downloaded, mostly because it's open access. And it is, I think the journal has made it open access because it's important for principals, teachers, and systems to read this work. And you can just Google missing the marker score in a gold Duncan, and it will come up and you can download it and read it. And if you're like me, I like to listen to, if it's complex. Some people think this article is complex. So if it's a piece of complex reading, I like to listen to it first. There are various apps that will help you listen to the article PDF and then read it. So I encourage you to do that because it goes into much more detail about how it's missed the mark. And then it being the legislation. And then also you can go on, and these are the links to the DDA and the DSE. And the DSE has supporting materials that are very user-friendly. And even if you don't read the DSE, just if you click on that or just Google Disability Standards for Education, it will come up, and look at the supporting materials because they are very accessible. So thank you very much for your time. I know it was a bit of a heavy topic. Now, if you have questions, just remember I'm not a lawyer. I'm a teacher of the deaf who is passionate about ensuring that all kids receive the education that's required in order for them to maximize their potential, their learning potential. So that is what I'm passionate about.
Thank you so much, Jill. That was very helpful, I guess, because I was one of the people who found that article very difficult to read. And I think having that overview is really very helpful. So we have a question in the chat, which I'll read to you. What are common reasonable accommodations made for hard of hearing children by education providers? I'm in the process of requesting sound field system for my child. The school has asked if we have any funds to contribute. Clearly, NDIS funds should not be used for this purpose, but wondering if this is a common accommodation that schools provide.
Absolutely a common, and it is the responsibility of the school. It's not the responsibility of the parent to provide technology for learning. That is the responsibility of the school, full stop. So definitely, sometimes for senior students, year 11 and 12, there's captioning, that's a reasonable adjustment. Sometimes for kids whose Auslan is their first language, an educational interpreter. Sometimes for kids who are deaf or hard of hearing with additional complex needs, teacher aid is a reasonable adjustment. I don't believe a teacher's aid should be used unless really thought out carefully. Sometimes there are accommodations made for assessments. That article goes into great detail about assessments and what reasonable accommodations or adjustments need to be made in regard to assessing students, for example, in that plan, etc. So those are common. Note takers can be a reasonable adjustment for deaf kids.
So Jill, sorry to interrupt you. At what stage would this parent discuss that with the school? So how would that parent, would they have to go back and say, look, we haven't gone through this process, or can we go through this process? How does a parent actually approach that with the school?
Thank you for asking that question, Anne, because what I think is really important, from my experience, when there are parents that are fighting with systems that I've been involved in as an expert, the parent is really angry, really, really angry, and fair enough, because their kids need a reasonable adjustment and they're not receiving them. But sometimes that anger can interfere with a good outcome. So what I suggest parents be as positive as possible with the principal. And I suggest that you keep records of everything, if there is, so it depends on who the decision maker is in the school. If there's a special ed teacher, start with the special ed teacher. If you're not getting anywhere, or teacher of the deaf, then to the deputy. Try to follow that hierarchy, then the principal, And then, and you could gently, nicely say you understand that it's important to have consultation first. You know, have the audiogram. If it's a real argument, it shouldn't be. Bloody heck, it shouldn't be an argument because everybody knows deaf kids need amplification. Get a letter from your audiologist to say, you know, remember how I said expert opinion may be required? And I can't think of an audiologist that wouldn't write a letter saying we recommend the child have this type of, you know, classroom amplification. So have your information, go to up the line, if you will. That's just my advice. You don't have to take my advice. Be as nice as possible, and but don't take no for an answer. Does that make sense?
Yep. Now I can remember talking to the education department in New South Wales, and they also really talked about it's really helpful if parents go through the, you know, start with the classroom teacher, then the teacher, and go through that process rather than trying to skip up the chain. That's often not as successful as if they slowly work through the hierarchy, I guess. So that is helpful. And I think also we always win with lollies or whatever rather than sticks, don't we? So trying to keep on side and keeping records, I think, is also really critical. I think that's shown time and time again that parents really need to take note of every time they have a conversation with the teacher, everything like that, they have a record of what they.
The other thing is professional learning. Ensure that the school, or encourage the school to have professional learning regarding deaf and hard of hearing children, because once they understand the importance of audibility of spoken language, you know, they're more inclined to support amplification of whatever kind.
So Jill, we have another question. Have you seen schools employ qualified Auslan interpreters? What do you think are the barriers to this?
Well, I have in WA. I lived in WA for 10 years, and there were a number of court cases. I think there are other states as well, but my experience was in WA, and it was a good while ago, so things may have changed. And the barrier, so yes, I have seen schools do it. And so it was a very high level understanding of the most senior people in the system, not the school, but the system, who respected the fact that kids needed educational interpreters, Auslan interpreters, when I was there in WA. So there was a high level understanding, and it cascaded all the way down to the classroom teacher. The barrier that we have, I think pretty much universal barrier, isn't there aren't very many interpreters available. We don't, perhaps there's a better way I can say that. The supply is not equal to the demand. Did I say that right, Bruce? I got my supply and demand wrong. But anyway, we don't have enough interpreters. And oftentimes as well, the pay isn't as good as it should be for educational interpreters. So they're not motivated to take those jobs. So we need to ensure that our interpreters are paid appropriately for the work that they do. So they need to be qualified, yes, indeed. And the school systems need to pay them appropriately. So that is the barrier. And yes, I have seen it work. I've seen independent and Catholic schools do it as well, but not as frequently, because like I said, oftentimes kids who are deaf or hard of hearing and general disabilities end up in government schools, because government schools frequently have more funding available to make the reasonable adjustments. Not always.
So I have another thought bubble, I guess, is that we quite frequently in our online groups, a parent will come on and say that the teacher won't wear the FM. They don't want to put the mic, you know, their clothes on right for the mics and all sorts of things like that. And of course, it's really confronting for the child to have to say something to the teacher. So, what, you know, in your experience, what should parents do in that situation?
I think, it puts an unfair burden on the child and on the teacher. Sorry, and on the parent, not the teacher. And in fact, it might be a burden on the teacher because they don't realize how much easier it would be to communicate with the child if they wore the microphone. And so could be a burden on the teacher as well. So I'd do the same thing that we spoke about, go up the chain, start with the teacher, and then the specialist, if it's a special ed or a teacher of the deaf, and then the deputy, then the principal. And, depending on your situation, if they really weren't doing it, then the system, but also ensuring that you have that professional learning, because some professional learning is many, many opportunities for brilliant professional learning. But once the teacher, I find this very effective, once a teacher hears what the student hears with the FM, and once they hear, because you can generate that artificially, once the teacher hears what the child can hear without the FM, they automatically, most of them, will make that. That's a reasonable adjustment. That is a very, very reasonable adjustment. There's no doubt about that.
Yeah. Does anybody else have any questions? Maybe you can unmute your mic and actually ask it instead of having to type. Happy for you to do that. Do you mind taking a couple more questions, Jo?
Sure, we've got a little bit of time.
Yeah.
It's hard, it's a hard topic. So I understand if you don't have a question at the moment, but on reflection, you could, I could take questions, you could give Anne questions and we could try to help create a fact sheet or something.
So Anne has said, what is your general experience with private schools and reasonable adjustments?
Well, it's changing. It's becoming more positive. Some schools, it's part of their mission to ensure that they have the same percentage of kids that require reasonable adjustment as independent. So they try to ensure that they enroll kids with disabilities and at the same level as, for example, government schools, because they enroll the most kids. What is your general experience with private schools? It depends on the school. Some of them have a religious mission to ensure that kids with a disability receive an education. Some of them view children with disabilities as bringing down their scores, their overall my school scores. The school doesn't rank as well for, in year 12 school leaving. And so they're hesitant to enroll kids with disabilities. So it really depends. It's mixed. All of the schools that I have been an expert for in Hunter have been private schools. And but it was a combination of harsh, negative, combative communication from all parties. The associate perhaps didn't understand the DSC, the DSDDA, and how to approach the school. So it was really a combination. But in the end, it was a student who suffered, and it was suffering, I think.
Yeah. And what about the classrooms where you have multiple classrooms, classes in one large classroom? Would that fall under the DSE?
Well, only if having a large open space multi-level classroom didn't provide education on the same basis as the kids without disabilities. So you could argue that it made the acoustics more difficult. You could argue there was more background noise, which made accessing audible, spoken language difficult. So you could argue that it was not on the same basis. And I have seen that happen. I wasn't involved in those cases, but I have seen, yes, you could definitely argue that.
Okay. Well, that's fabulous, Jill. Thank you so much. I really appreciate your time and knowledge and expertise that's been really helpful. I'm sure the people who were involved have appreciated it, and we will be putting it on our website so that others are able to review it, I think, at their own time. So thanks so much, Jill. I really appreciate it.
It's a pleasure.
Yep. And thank you everybody for joining us today. See you.